which will be delivered by Justice Sujata Manohar, and Justice B.N. Sri Krishna will be in chair for today's speech. The topic, as you all know, access to justice and public interest litigation. I request the speaker and the chairperson to take their seats, please. Before we begin, for all of you to just a request to switch off your mobile phones or keep on silent mode. Bansari Seth inherited affinity to law from her mother's side. Her mother's grandfather also was the first Indian to be appointed judge of the Bombay High Court, and that is why, since childhood, she really loved to learn law. She went to Elphinstone College and then took her LLB from Government Law College, Bombay. In the late 50s and early 60s, she taught law at the Siddharth College of Law, besides embarking on a career of independent practice on the original side of the Bombay High Court. She went to USA in 1965 and obtained her MA in English literature also and business administration. She won prestigious fellowship of the Council of International Progress in Management, sponsored and supported by leading corporations of the USA. When she came back to India in 1969, she took up independent consultancy in business management and legal work for leading companies. This finally led her joining the well-known firm of Tayyabji Dayabai. She was a partner in the firm in the last. She joined our society as a member in 1949, and then holding different positions in managing committee as vice president, finance secretary, etc. She served the society from 1971 to 1985. She passed away in 1991, and her family members had established this endowment and for an annual lecture, which is the subject dear to her heart, that is society and law. So today's theme of this endowment is society and law. We have had all 24 years this lecture without any break, and today is 25th lecture. Today's speaker, Mrs. Sujata Manohar, Justice Sujata Manohar, as I would like to say, I welcome her doubly for our speech, as well as being the speaker, as well as today being the International Women's Day, the first lady. She graduated with first-class honors in philosophy and Sanskrit from Bombay University, then MA from Oxford University in philosophy, politics, and economics, and barrister at law from Lincoln's Inn, London. You know how prestigious this is. She was an honorary fellow of Lady Margaret Hall, Oxford, and honorary bencher of Lincoln's Inn, London. She was the first Indian judge to be so honored in those days. She was, of course, last year only awarded the honorary fellowship of our society, Asiatic Society of Mumbai. She had other honorary doctorates also from various universities in India and UK. She was the chairperson of Board of Trustees of our society. Basically, I want to tell all these, particularly these students, those who are very willingly have come to listen to her. She is the first woman judge of the Bombay High Court, became the Chief Justice of the Bombay High Court, and thereafter of the Kerala High Court in 1994. She is the first woman Chief Justice of both the High Courts, and in November 1994, she was appointed as Judge of the Supreme Court of India and retired in 1999. She was appointed thereafter National Human Rights Commission in 2000, Then she was chairperson of the Committee on Feminism and International Law of the International Law Association and consultant to the UN expert group on trafficking. She was also consultant to UN expert group on women, peace and security. Currently an arbitrator in national and international disputes. Today I welcome her, as I said, that International Women's Day, as well as being so many places of the first woman judge. So I really feel very happy to ask her to come here, and she has accepted. So it is really a great privilege for us. Today, Chairperson Justice B.N. Sri Krishna is also our former trustee, and he mainly was known for the Sri Krishna Commission of Inquiry on Bombay riots of December 92 and January 93. He was former chairman of Six-Pay Commission, all different positions he held in different courts, high courts, and appointed by the Government of India chairman of the high-level committee to take forward institutionalization of arbitration in India. His current positions are legal counsel, doing chamber practice on retirement from Supreme Court. He is a member of panel of arbitrator of SIAC. Vast experience for so many years. He knows many languages, and I have experienced how fluent and how well-read he is in Sanskrit. He had already published few books, which are one chapter on judicial independence in the Oxford Handbook of Indian Constitution, which is published by Oxford University Press, chapter on foundations of ancient Indian society in Courts of India, published by the Supreme Court of India, then papers, so many research papers on various subjects. One paper's title, though I have not read, but interested me, that is Maxwell versus Mimamsa. You can see that how well he is read and how in depth he has studied these subjects. So I welcome both these honorable and distinguished speaker and chairperson, and ask our president to welcome them by a small gift. This is a memento of Asiatic Society, which has books instead of a book. I welcome all of you, especially these students, those who have come from very far to listen to these two distinguished people. And I'm very happy that they are all well set over here and remember to follow the discipline of the hall. Thank you. Sujata Manoharji.
Justice Sri Krishna, Mr. Khaled, Justice Gokhale, Justice Mrs. Matre, office bearers of the Asiatic, and ladies and gentlemen, and students, of course. With this lecture, we complete a quarter century of lectures in the memory of Bansari Sheth. I had delivered the second memorial lecture in 1993 on law as an instrument of social change. And I feel very privileged to deliver this 25th memorial lecture. I had known Bansari Kaji, as she then was, when I joined the bar in 1958, and she used to be the junior of Mr. J.M. Thakur, who later became the Advocate General of Gujarat, one of the longest-serving Advocate Generals in the country. The Asiatic Society was fortunate to have her services. She was the secretary of the society for a long time, from 1976 to 1985. Her passing away has been a great loss to the society. It's difficult to find dedicated workers, and we must thank her family members for perpetuating her memory in this way. Now, as you just heard, this lecture happens to be delivered on International Women's Day. It is, I presume, a happy coincidence. Though the lecture is not about women, it does have a special relevance to women. In fact, one of the earliest public interest litigations was to help women in the protective home for women at Agra. The need to provide effective access to justice to women in distress cannot be overemphasized. So, in many ways, this lecture also does have a relevance to Women's Day. Now, I'm going to deal with two connected subjects in this lecture: access to justice and public interest litigation. We have in our culture a deep-rooted sense of justice and a sense of right and wrong. Some of our great kings in the past have been admired for their sense of justice. You remember King Vikramaditya and his famous judgment seat. Then we had Emperor Ashoka and his edicts, and Emperor Jahangir. Jahangir had a bell on the ramparts of his fort with a rope tied to it going down to the road below. Anyone could access justice by ringing the bell. We have not been able to devise anything as simple or as effective. Justice itself has several dimensions, and we have a very complex system laid down by the Constitution to deal with justice in all its facets. Now, we do take pride in our Constitution and a democratic way of governance that is governed by rule of law. Now, rule of law requires an effective system of administering laws framed in public interest by people's representatives, and it requires an independent judiciary to interpret and enforce the law, to deal with breaches of the law, or even at times to lay down the law to render justice. It is important that access to justice is available to anyone in need. Now, let me put it in the words of Lord Mackay of the House of Lords. He says, "A system for the administration of justice, which is not in a substantial degree open to all, is unworthy of the name and is potentially a threat to the unity and stability of the community which it purports to serve." For an effective system of administering justice, there must be, 1, a good constitutional and legal framework; 2, a responsive administration that works to carry out the constitutional and legal objectives and which treats judicial decisions with respect; and 3, an independent and impartial judiciary that deals with breach of any law, that interprets and applies and at times innovates the legal framework to ameliorate the grievances before it. The prime task of providing to people access to justice, therefore, must remain with the judiciary. An effective judiciary which commands the respect of its people must have independent judges who are men and women of integrity and are not subservient to power, whether of the government or of any other private agents. Independence of the judiciary is unfortunately still a question in many countries, and the United Nations had appointed a special person to be in charge of promoting independence of the judiciary. And it is not unknown for the government to desire pliant judges or judges who support the political philosophy of the ruling party. There is one more prerequisite for effective access to justice: speedy adjudication. Heavy arrears and the resulting delay in deciding cases block speedy adjudication, and delay to some extent or the other has plagued many countries, and it plagues our country in a very substantial way, I'm afraid. So in the present lecture, I would like to focus on providing access to the judicial system to all who need it. Constitutions of many countries guarantee freedoms and human rights, but it is universally acknowledged that the enjoyment or exercise of these freedoms and rights to a very large extent depends upon the existence of easy and expeditious access to the courts that deal with such breaches. The countries that acquired freedom from the colonial rule past Second World War and set up democratic forms of government are acutely aware that one can hardly speak of rule of law if there is no right or a restricted right of access to the courts. Justice Magoro of the Constitutional Court of South Africa said, "The right of access to court is indeed foundational to the stability of an orderly society. It ensures peaceful, regulated, and institutionalized mechanisms to resolve disputes without resorting to self-help. The right of access to court is a bulwark against vigilantism and the chaos and anarchy which it causes." I think these are words which we should remember. Now, who can access, or who cannot access the judicial system? Now, who are the people who have difficulty in approaching the courts for the enforcement of their rights? First, the poor, the jobless, or the economically disadvantaged people. They cannot afford legal advice and help, or the cost of litigation, and hence cannot resort to courts for redressal of wrongs. Two, socially disadvantaged groups or victims of social prejudice, such as Dalits or tribals or backward classes, who are discriminated against for various reasons. They do not have faith in the existing systems and are reluctant to approach the courts. This group can also include, at times, minorities, whether racial, religious, or linguistic. Women also have problems moving the courts for various social and economic reasons. Then the third category is of those who are otherwise handicapped, such as bonded labor, destitutes or street children, mentally and physically handicapped people, inmates of special institutions like women's homes, children's homes, homes for the mentally challenged, and so on. And the other category is of under trials in jail or prisoners. Obviously, the problems of each group are different, and the reasons for the lack of ability to move the courts are also diverse. However, there are certain common factors which apply to all of them. Let me enumerate some of these factors. Foremost amongst them is a lack of knowledge of their rights. Illiteracy is still widely prevalent in terms of actual numbers in our country, and this is an important reason why people do not enforce their rights. For example, in the last 50 or 60 years, there has been a substantial improvement in the legal status of women. Yet most of the women do not know their legal rights and hence are deprived of them. Many, for example, do not know their entitlement to a share in the joint family property. In fact, this is one of the standard questions which is asked whenever I go to address a women's group. The National Human Rights Commission and the state human rights commissions have been entrusted with educating people in respect of their human rights. And one hopes that they will ultimately be equal to their task. Media also has an important role to play in educating people about their rights. One must, however, remember that greater awareness of rights will also bring more cases before the courts. We have to expand the court system adequately in advance to deal with such increase in litigation if people are to enforce their rights. Then cultural ethos can often prevent resort to litigation. For example, There's a strong social pressure preventing women from enforcing their rights against their own brothers or family members. The Dowry Prohibition Act is an example of legal protection not being availed of on account of cultural pressures. The cultural bias is also explained to a large extent why crimes against women are not registered by the police or are not investigated properly. Society looks upon such crimes as a family's internal matter. In fact, one of the women police officers at one of these conferences said that we have more important crimes to investigate. So this is the cultural attitude. The police gives very low priority to recording and investigating such crimes, and without proper investigation, crimes cannot be punished. Now, we have amended our laws, as you know, to curb violence against women. For example, in the case of custodial rape, there is a presumption that the woman was prevailed upon and did not give her consent. If the death of a woman is caused otherwise than under normal circumstances, say burns or body or something like that, within 7 years of marriage, and there is a history of harassment by her husband or in-laws in connection with dowry, then there is a presumption that they have caused her death, and this is called a dowry death. Even in such situations, cultural bias often prevents proper investigation and prosecution. A group which has been discriminated against for generations develops also a psychology of resignation to its fate. It does not hope for any justice at the hands of the dominant group. Some crimes against women, such as rape, carry a stigma against the victim, so that even when such a group is granted legal protection, it is reluctant to come forward to claim it. The Dalits even fear reprisals if they claim legal protection. In such a situation, considerable field work by supportive organizations is needed before the repressed group will avail of any legal remedy. Ignorance of how to approach the system also deters the underprivileged from availing of legal remedies. For people such as inmates of special institutions or protective homes or bonded labor, it is impossible to approach the system without outside help. And the other important factor which we must take into account is the cost of litigation. The cost factor also inhibits access to lawyers of reasonable competence so that the aggrieved may not get the correct legal advice or proper assistance. We have tried to remedy the situation by providing state-sponsored legal aid. But unless we are able to attract competent lawyers into this system, it may not work as efficiently as it should. We do not have public interest law firms, for example, that will take up cases of the underprivileged free of charge or at reduced fees. NGOs and private groups need to provide such support in a big way. Now, our Article 39 of the Constitution was amended in 1977 to provide that the state shall secure that the operation of the legal system promotes justice on the basis of equal opportunity and shall in particular provide free legal aid by suitable legislation or schemes. This article and Articles 21 and 142 were relied upon by the Supreme Court in the case of Hoskot versus State of Maharashtra. This was in 1978, to hold that a prisoner must be provided a lawyer in appropriate cases. Then in Sukhdas versus Union Territory of Arunachal Pradesh in 1986, the Supreme Court held that the court had the obligation to inform the accused of availability of free legal aid. A conviction without imparting such information would be vitiated. And then in 1987, much after these cases, the Parliament passed the Legal Services Authority Act, for free legal aid to the poor. It also provides for lok adalats for free and speedy justice. I'll deal briefly with lok adalats. So, we have set up from time to time lok adalats or people's courts to bring about a settlement of pending disputes before the courts. The court consists of benches of either eminent lawyers, retired judges, and at times also social workers. It is constituted ad hoc for the day. Certain types of pending cases which have been previously selected from the court file by the committee as likely to be settled are placed before this court, and if a compromise is arrived at, the case is placed before the judge for a consent decree. A very large number of cases can be disposed of during the day. Lok adalats have, however, met with a mixed fate. They have been highly successful in certain types of cases, such as accident claims, when the representatives of the insurance companies have attended with the authority to settle claims, but not otherwise. Maintenance and custody disputes have also been reasonably well tackled by such courts, but an intelligent selection of cases and an efficient group which organizes such sittings after proper spade work, both are necessary for a successful session. When these have been absent, the sittings have not been successful. A legal aid program, whether governmental or private, must include disseminating information about laws and legal rights. Some work is already being done, but much more needs to be done in the area of educating people in their rights and legal redressals. The legal aid program also needs to be more comprehensive. It must include campaigning for welfare legislation, because those who operate the system know best where the problems are. Legal aid workers should pinpoint such problems and seek remedial measures. The Indian Supreme Court has developed a special method of providing to the disadvantaged and the underprivileged access to the judicial system. Public interest litigation has been fashioned by our courts to provide such groups the benefit of the system. The Constitution has made human rights or fundamental rights justiciable, and the right to move the Supreme Court for the enforcement of these rights is itself a fundamental right. In this situation, it was necessary to devise a method for giving all such disadvantaged groups access to the court system. Ordinarily, only a person who has suffered a wrong can move the court. We call it, in legal jargon, locus standi of the person moving the court for relief. In 1980s, the Supreme Court, under the leadership of two judges, Justice P.N. Bhagwati and Justice Krishna Iyer, expanded the concept of locus standi. It permitted enlightened and public-spirited citizens or organizations, not necessarily belonging to the group on whose behalf they litigate, moving the judicial system on behalf of those who are unable to move the courts. This is a widening of the class action evolved in the United States, particularly by the National Association for the Advancement of Colored People. Public interest litigation, or PIL for short, has expanded the scope of such representative action. Now, let me talk about locus standi. PIL has permitted a wide range of third parties to intervene on behalf of the underprivileged. In the case of Bandhua Mukti Morcha versus Bihar in 1984, which was a social action litigation for the freedom of bonded labor, the Supreme Court of India laid down two tests for permitting an organization or a group to sue on behalf of others. One, the group making a vicarious claim on behalf of others must not have any axe to grind, and should be actuated by altruistic motives. Now, this is difficult to ascertain in all cases. 2, the persons whose rights are asserted are not in a position to come to court due to poverty, ignorance, or some such handicap. The Indian Supreme Court has been liberal in granting such locus. For example, in the case of S.P. Gupta versus President of India, a case well known for other reasons, practicing lawyers were allowed to challenge the government policy of transfer of judges. In Sheila Barse versus the state in 1983, a single woman journalist was allowed to sue on behalf of women in police lockup who were ill-treated. The same woman journalist was later allowed to sue on behalf of children in an institute run by Children's Aid Society. In the latter case, an interesting situation arose when the woman journalist later, for various reasons, sought to withdraw the petition. She didn't want to proceed further. The Supreme Court said that the petitioner may withdraw from the case, but since it was a public interest litigation, the petition would remain. In the case of Forward Construction versus Prabhat Mandal, the Supreme Court held that even though a previous litigation had been fought on the same issue, it did not debar appeal because the earlier litigation had not been on behalf of the public. Now, I'll tell you a little bit about the history of pill. In 1976, possibly the first pill was successfully fought in the Bombay High Court by some public-spirited citizens, members of parliament, and members of the Maharashtra Legislative Assembly. Pilu Modi, Brunal Gore, and the rest of them had moved this litigation, challenging the sale by the government of reclaimed land in Bombay City near Nariman Point to prevent private builders at a very low value, to prevent land being given to private builders at a very low value. The Battle of Locust Standi, which was very new in those days, was fought for several days, and the Advocate General addressed the court against it. But ultimately, the court held that these people could fight a litigation. Obviously, the main factor which tilted the balance in favor of pill was that the aggrieved public, which had been deprived of substantial public funds, had no other remedy in the face of a defiant administration. By now, pill is well entrenched in the Indian soil, and locus is easily granted if the court is satisfied about the bona fides of the petitioner. The credit goes to the Supreme Court for this. One of the first cases of public interest litigation, Hussain Ara Khatun versus the state of Bihar, arose out of 2 articles published in the newspaper Indian Express in January 1979. These articles were written by Mr. Rustamji, a member of the National Police Commission. He highlighted the plight of under-trial prisoners languishing in various jails in Bihar for long periods for no reason other than their inability to furnish the bail amount. This led a Supreme Court lawyer to move the Supreme Court in habeas corpus. The petition was allowed, and it resulted in the release of over 40,000 under trials from Bihar jails. Another such litigation on behalf of inmates of the Government Protective Home for Girls at Agra was at the instance of an eminent law professor, Dr. Upendra Bakshi, and such public interest litigation has now been permitted in field of human rights in a big way on behalf of just slum dwellers, for example, that was Olga Tellis, construction workers, inmates of Ranchi Mental Hospital, dealing with police excesses, the Sheila Barse case, bonded labor, and the like. It has a long history of acceptance in various other areas, such as protection of the environment, protection of forests, these are those Godavarman cases, the location of industries, implementation of town planning programs, malfunctioning of municipal administration, dereliction of duty by a public body, and so on. It was used for protection of children being given in adoption. These are the Lakshmikant Pandey cases, or protection of working women in the Vishakha case. An individual may be unable to establish in such a situation a specific damage to himself in the traditional sense. Yet, the administrative action or inaction may have a long-term detrimental effect for the society as a whole. With the help of pills, such grievances can be litigated by a public-spirited group or organization, or even by an individual. It can also be used to litigate on behalf of a very large number of people who have suffered a common harm, such as in class actions in the US. You remember the thalidomide baby cases. The more recent examples, the last year, are for establishing, as you know, you must be remembering, a right to privacy or a challenge to triple talaq. The latter was both a class action and a pill. Interestingly, even in criminal cases, where the accused in crimes such as rape or wife burning are acquitted, women's social groups have been allowed to intervene. Bill has also been used to prevent misuse of constitutional provisions. For example, misuse of power by the governor of a state to issue ordinances was questioned through a bill. The question whether the Prime Minister of India can be appointed when he was not a member of either House of Parliament was also raised through bill. At times, there may even be a clash of public interests. Putting up a plant may pollute the environment, but it may also provide thousands of local jobs. Or there may be a clash of need for energy versus need to preserve ecology. There is no doubt that the court has become a battleground for interesting and even conflicting ideals and ideologies. In fact, the frequent use and at times even misuse of this facility has raised concerns. When should public interest litigation be entertained? For those who have questioned the relaxation of the rules of locus standi, let me quote the High Court of Tanzania. I like to go to these courts because they've followed the lead given by India. Now, this court, the Tanzania court, High Court, also entertained public interest litigation, and it has said, if there should spring up a public-spirited individual and seek the court's intervention against a legislation or actions that pervert the Constitution, the court, as guardian and trustee of the Constitution and what it stands for, is under an obligation to rise to the occasion and grant him standing. Other countries, especially in Africa, which have a sizable population of underprivileged, have all accepted public interest litigation as a legitimate method of moving the court. I know of one country, only one country, which has made a constitutional right to move a bill. The Constitution of Uganda, for example, under Clause 3 provides that any person who alleges an act of parliament or any other law or anything done under the authority of any law or any act or omission which is inconsistent with or in contravention of the provisions of the Constitution may petition the Constitutional Court for a declaration to that effect and for redress where appropriate. And Clause 4 gives power to the Constitutional Court to grant a declaration in order to redress, or it can refer the matter to the High Court to investigate and determine what is appropriate redress. As a result, the Constitutional Court in Uganda has taken an active role to protect the rights of citizens. So we need to strengthen and not abolish public interest litigation. But we do need to introduce a system which will govern such litigation. In Sunil Batra cases, the Supreme Court set aside procedural requirements and entertained petitions relating to ill treatment of a prisoner in jail conveyed to the court through a postcard by a fellow prisoner. Then, looking to the nature of the complaint, the court entertained the petitions. But this led to random entertainment of cases on the basis of newspaper reports or such other pieces of information by the court. This has some obvious pitfalls. Acting on an unverified or unreliable report may land the judge in an embarrassing situation. Similarly, to act on a letter without the aid of any facts which the petitioner may be required to bring before the court would also be inadvisable. Hence, legal aid agencies or public-spirited lawyers are asked to take up the cases, what we call amicus curiae. Ironically, so, an informal procedure also needs a structural framework if the system has to work. In 1988, if I remember rightly, the Supreme Court had framed some guidelines which unfortunately were not made a part of the rules of court. Another attempt was made by the Supreme Court in 1996. There are some important principles which should be kept in mind before the court entertains a bill. First and foremost, the court should be in the position to handle the issue effectively and should be able to enforce its orders. The authority of a court is eroded if its orders are not implemented. When the grievance relates to continuous ill treatment or continuous pollution, obviously a one-time order cannot serve any purpose. The courts have had to lay down administrative guidelines which have to be carried out from day to day. To supervise this, commissions have been appointed. Once again, the limitations of the court system have had to be overcome through the help of outside public-spirited experts who are willing to act for a period of time. The courts may also have not available to it either the expertise to lay down guidelines or adequate data. Fortunately, the problems get mitigated when the experts themselves come before the court if the administration is unresponsive. For example, long time back, in a case to contain noise pollution, the petitioners were members of an expert body, including medical practitioners. As a result, a highly qualified expert committee was set up. The municipal and police administration agreed to cooperate, and a successful program of noise containment was launched in those days, which worked for 8 to 10 years, but not thereafter. The court merely brought about coordination where none existed. A similar committee on the state of the roads was effective for some time. And if you remember, even today we have a committee of public-spirited citizens who supervise the condition of Chowpatty Beach. The Supreme Court, in the case of adoption of children by foreigners, laid down effective guidelines because of the expert assistance it got from Indian Council of Social Welfare and other social welfare organizations. However, commissions, committees, and guidelines are not always successful. And an administration bent on thwarting court's directions can usually, I'm afraid, outmaneuver the court. As a result, both the status and authority of the court can get eroded. Obviously, the widened jurisdiction must be exercised with circumspection, in suitable cases only, and not blindly. The Indian Supreme Court has emphasized that bill is not an adversary type of litigation in order to enlist the cooperation of the administration. Next, there must be an in-house machinery to check when a bill is filed, whether the petitioner have the necessary expertise to assist the court, whether the petitioners have a record of public service, and things like that. This will amount to checking the bona fides of the petitioners and whether they have a track record of public service. In cases where an expert opinion is required, such as in respect of noise pollution or environmental issues or issues relating to public health, the expertise of the petitioners becomes extremely important. Otherwise, the court must insist that expert briefs be filed in such litigation. Therefore, ultimately, an important consideration is, will the court be able to monitor implementation of its orders? Is it enough to have ad hoc court-appointed committees to monitor implementation or expert committees to evaluate and make recommendations? At times, so the court also looks to the expert committee for its opinion before it frames its orders. So it is a very difficult situation in which the courts are. They have to now devise a suitable method of implementation of orders in such public interest litigations. For some time, the Supreme Court and the National Commission had worked together for monitoring orders of implementation. For example, the National Human Rights Commission was directed by the Supreme Court to supervise and monitor protective homes at Agra, Gwalior, and Ranchi. Now, NHRC has the machinery to do this. And it also, for example, worked to implement Vishakha guidelines, setting up committees in public sector and in government departments. So we have to see what machinery can be available to the court for implementation of its orders. So we need a very different kind of approach in such courts. There is no doubt that public interest litigation has made the judicial system relevant to the lives of ordinary people of this country. It is, in my view, a remarkable gift of the Supreme Court to the country, but we need to learn how to prevent its misuse and use it effectively for public benefit. Now, what do we expect in the future? Let me conclude by just saying that in the US, public interest movement has been going through a transformation, possibly on account of the Supreme Court's present composition. From a reliance on litigation as its basic weapon, the people have now moved to a much wider variety of political tools, including monitoring of administrative decisions, legislative lobbying, and direct political action. You see that every day in the news, something or the other. Perhaps the same may happen in India with an increasing awareness of legal and constitutional rights. The Indian experience of Bill, I hope, will be of relevance to other Commonwealth countries similarly situated. It is an effective weapon with which the weak are challenging the strong. Whether with the help of Bill, they will triumph over the strong in the long run in their battle for socio-economic equality remains to be seen. But given proper support, I hope they will succeed. Thank you very much.
Hello.
Do you have some questions? Would you like to raise some questions, ask for some clarifications? Our President, Mr. Kale, suggests that we could start with the students before we come to members. So any student who may have a point to raise. Well, I hope you've been able to absorb all the information that's been provided and you can carry that back with you. So do I take it that none of the students have any questions? Okay, well, it's open to the House if anyone would like to check on things. Yes.
Madam, there are number of years the judicial system is such that justice is getting delayed. There are number of dates and dates are who are receiving. Whereas I would like to say that justice must be delivered in time. It should be a time bomb. And the entire laws which are there from beginning of the Britishers' times has to be modified. That is first question. Second question is there is no special code against the lawyers, because I have bad experience of cheating by the lawyers itself, and I filed a complaint in the bar council. Not a single, there are 7 advocates against which I filed. Record of the bar council is very bad, because their friends itself, they are sitting in front of them as a judge, and they are giving all the justice from the advocate side itself. So can you please highlight on?
The question undoubtedly is a very important question. The question undoubtedly is a very important one. We have been grappling with it for the last 150 years in the Bombay High Court, and probably some of the judges abroad have grappled with it for a larger period of time. Now, none of us has been able to come out with some kind of epiphany and a solution to it on the spot. Now, if the gentleman has something to tell us, we would love to know what should be done to speed up the process so that we can also attempt to do it in our own humble way.